All right, hello and welcome to Loquitur's self-paced, online, witness familiarisation training course for lay witnesses. I'm Tom Nevin, a director here at Loquitur, and thank you for taking the time to check out this course. This course is specifically designed to assist lay witnesses, also known as factual witnesses, prepare to give evidence in court. We have a series of separate courses for expert witnesses, both in-house and online. Details of these can be found on our website. Now, this course is very detailed. It has 10 modules totaling about 3 hours of teaching time, plus 2 to 3 hours of preparation and coursework. So, what's the purpose of this course? The primary purpose of this course is to build lay witness confidence when giving evidence under cross-examination. It's designed to give lay witnesses an awareness of the court and evidential processes and to allow lay witnesses to develop an understanding of advocate strategies in cross-examination. Now, this is something barristers have had years of training and experience doing. Many of them cross-examine witnesses on a weekly or in some cases daily basis. And this obviously leaves lay witnesses at a significant disadvantage when it comes to cross-examination. And our course seeks to help level that playing field. You will learn what these strategies are and, perhaps more crucially, how you can recognise them when they're done to you under the pressure of cross-examination. We'll teach countermeasures to those strategies and provide practical examples in the application of these. So, some points in relation to our course. Our course has an Australian focus, a focus across courts in all state and federal jurisdictions throughout Australia, as well as inquiries, tribunals, and arbitrations. Having said that, of course, the principles and teachings are also very applicable to international arbitrations and apply in other common law jurisdictions. For example, New Zealand, the UK, the US, Singapore, and Hong Kong. This course also has a focus on civil cases, but the same principles apply in criminal matters, albeit with some procedural differences. Note in relation to these courses that the people in these courses are not actors. They are learning just as you will be, although it should be noted that those people in this course did not undertake this course in advance of any proceeding or hearing at which those people would be giving evidence themselves. So, looking now at the ethical framework under which our training is conducted. What this course is not is it is not a consideration of the actual evidence that you will give as a witness. We cannot and we do not know any witness's evidence, and there are very strict ethical rules regarding this. The dealing with the witness's actual evidence is the role and the sole role of the witness's legal team. We do not, and indeed cannot, give legal advice. Indeed, we are not a law firm, and we don't know anything about your precise position, and thus cannot give you legal advice. Again, if you have any specific questions in relation to legal advice, this is something you have to ask your own lawyers. We also cannot tell you what to say. Indeed, no one can. But what we do, however, is help witnesses gain an understanding of all of the legal and evidential processes and to assist them in the delivery of their own evidence in court under cross-examination. This is an additional level of training and preparation for lay witnesses to complement and assist the legal team's preparation of their witnesses for trial. So, our trainer, Hugh Stowe. Hugh is a practising commercial barrister at 5 Wentworth Chambers in Sydney. He's a very experienced barrister and is also a former solicitor and is currently an advocacy instructor at the New South Wales Bar, where he teaches trainee barristers how to cross-examine witnesses. Hugh has a particular practical and academic interest in the provision of evidence to courts, and Hugh has published several papers and presented at various conferences on this topic. Hugh is exceptionally well placed to take you through this course, and we are sure that you'll appreciate his knowledge, his comprehensive but casual teaching style, and his very incisive skills as a cross-examining barrister. All right, now moving to the content of the course itself, we start, of course, with Module 1, the General Introduction. In this module, you'll learn about the training itself. You'll understand the legal and the ethical obligations of witnesses, of lawyers, and of Loquitur and our trainers. This is obviously a very important section, so witnesses know what they can do, what they can't do, and also what they can and cannot expect from their legal team, and also from Loquitur. Module 2. Here we look at the trial process and the role of the court, the different types of witnesses, for example, lay witnesses or expert witnesses, and their role in the proceedings. We discuss the practicalities of giving evidence on the day, how to prepare, what to wear, where to sit, what will happen, etc. Module 3, the giving of evidence itself. Here we look at the phases of witness examination, cross-examination being the big one. We give some basic tips and considerations and pointers for witnesses when actually giving their evidence. There's quite a bit in this section that all witnesses should be aware of when delivering their own evidence under cross-examination. So Module 4, cross-examination strategies. In this module, we teach a series of cross-examination strategies used by advocates when cross-examining lay witnesses. We teach you, as a witness, how to recognise these strategies when they're done to you in the witness box, even when under the pressure of cross-examination. We teach how you, as a witness, can respond effectively to these strategies to deliver your own evidence. There are quite a lot of strategies. You can see them listed now on your screen. We teach them all in quite some detail. It's a big module, and perhaps one of the most fascinating. Hugh really opens up on the dark arts of witness cross-examination by barristers. Module 5, boxing in the witness. Module 5 is the first of a series of practical modules where you can watch and understand a series of mock cross-examinations. You can see how the strategies we've previously taught are employed by barristers and how witnesses can and do respond in practice to mitigate those strategies. We give feedback on those sessions as well. Now, the first of these is an example of how barristers can box in the witness and thereby discredit the witness or limit any further evidence the witness provides. Now, this is a very common tactic which is used by barristers, and it's one which all witnesses should be alert to. Module 6, witness concessions and open textured standards. In Module 6, we continue with these practical sessions and feedback. In this session, we take a particular look at how advocates get concessions from witnesses. We see where concessions should be made by witnesses and may in fact boost a witness's credibility by giving the concession. But we also see where the barrister extracts concessions from the witness which may have been unnecessary and which are in fact actually inconsistent with their evidence in chief. We also look at the issue of open textured standards and how these are used by barristers to challenge the witness's evidence, and how you, as a witness, can also use these to your advantage during cross-examination. This next practical example shows how a barrister may use a charm offensive against the witness. This is a very common tactic and can be especially damaging to certain types of witnesses. We see how this charm offensive will be turned against the witness, including when the barrister changes tack part way through the cross-examination to then bully and intimidate the witness. This session also highlights the use of evasive mantras by witnesses. Again, witnesses regularly revert to these evasive mantras when backed into the corner and we see how these can be detrimental to the witness's evidence. We also consider tactics that witnesses could use instead. Okay, Module 8, dealing with awkward facts and what would the reasonable and prudent person do. In this next practical module, we highlight how witnesses can address awkward and difficult facts in their evidence. After all, you generally would not be being called as a witness unless there were some facts which opposing counsel wished to challenge you on. We also see how cross-examining advocates can use these facts against witnesses. This module also illustrates the reasonable and prudent person trap, which is often used by barristers. And we see how this can be best addressed by witnesses to give the witnesses own evidence. Now, Module 9, being careful versus being cagey, and how to make a barrister do the work. This module delves into the practical dilemma facing witnesses, how they must be careful in answering questions, yet not be, and certainly not appear to be, cagey or guarded in your responses. Now, being cagey or being wary is a very natural reaction when cross-examined, but it's something which can adversely affect the credibility of your evidence. This module shows how witnesses can make barristers work as part of the cross-examination. Now, this is a very helpful technique for witnesses to take the initiative as part of their cross-examination. Direct challenges to your evidence and some further observations. This final practical module carries on addressing awkward and difficult facts for lay witnesses. They will inevitably arise in most cross-examinations, and we see how they can be both used by barristers in cross-examination and addressed by witnesses effectively. We see how these facts can give rise to direct challenges by counsel to the witness's evidence. And we also provide some final thoughts and tips for witnesses when giving their own evidence. So that is our online lay witness familiarisation course in a nutshell. We're sure you'll find the course interesting and perhaps even enjoyable, and that you will learn a lot. If you have any questions or comments during the course, please do not hesitate to let us know using the course chat function. If you are interested in further training on this topic, we have various options available, including live, intensive mock cross-examination sessions for lay witnesses in small groups. This allows witnesses to really get a chance to put the strategies learned in our course into practice while under the pressure of cross-examination, and also to get some feedback from our trainers specific to you, what you personally do well as a witness, what your bad habits are, and how you can improve them. We also have training on other topics, including for expert witnesses and for other professional witnesses, such as public servants, emergency services, and health professionals. Please do not hesitate to contact us regarding this. Details are below and on our website. Thank you.